May I once again request all the participants to kindly take your seats. The chief guest and the guest of honor would be arriving in any moment. All the participants at the back, please kindly take your seats. And may I request all of you to put your hands together to welcome them. May I also request Divine Pastor to join on the dais. Friends, it's a very rare occasion for the City of Joy to have such accomplished people coming together and agreeing to share knowledge with us. Thank you very much for your kind presence, sir. Thank you very much. We are really elated today. May I request all of you to kindly settle down. Friends who are standing at the back, please kindly take your seats so that we can begin our program. Good morning, everyone. Before I start this program, I would request all of you to kindly rise for the national anthem. So we would like to begin our session with the lighting of the lamps. So may I request all the dignitaries on the dais to kindly step forward, and also request all the guest speakers to kindly come forward and join for the lighting of the lamp ceremony. May I also request the office bearers of the ACI to kindly step forward. May I also request the of the Eastern India Regional Council kindly step forward for the lighting of the lamp. Please come forward.
Sir, photo.
Guest of honor is amongst here today. Thank you very much for all your efforts. I would now request the convener of the Association of Chartered Accountants Study Circle to kindly felicitate our chief guest, Honorable Mr. Justice Krishna Munari, by offering a bouquet followed by a shawl and the memento.
Hey, look the kid.
May I now request Mr. Kamal Nayan Jain, the past president of the Association of Chartered Accountants of ACA Study Circle, to kindly come forward and offer a flower bouquet to Justice Rakesh Kumar Jain. Also request Neeraj and Vasudev Agarwal, past president, to kindly come forward and offer a shawl and memento. तो ताली में थोड़ा कंजूसी नहीं करें, ये बहुत रेयर मोमेंट है when we have such accomplished guests amongst us. Please put your hands together. We also have Mr. Atul Nanda amongst us, and I would request CARR Modi to kindly come forward and offer a bouquet to him. CA Santosh Rumta to offer a shawl to him. Followed by CA Ravi Patwa, a past chairman of the Institute of Chartered Accountants, to offer a memento. आइए. Thank you, sir. Thank you very much. Something in brief about our guest today, Honorable Justice Mr. Krishna Murari. He is the sitting judge of the Honorable Supreme Court of India. Born on 9 July 1958, he obtained his LLB degree from Allahabad University. Enrolled as an advocate on 23rd December 1981. He practiced in the Allahabad High Court for over 22 years in civil, constitutional, company, service and revenue matters, and has specialized in civil revenue and service cases. He was appointed as Standing Counsel of UP State Yarn Company Limited, Kanpur, Northern Railway Primary Cooperative Bank Limited, UP State Textile Corporation Limited, Kanpur, UP Cooperative Spinning Mills Federation Limited, Kanpur, and Bundelkhand University, Jhansi. He was also appointed as an additional judge of the Allahabad High Court on 7th January 2004 and appointed as permanent judge of the Allahabad High Court on 18th August 2005. He took over as Chief Justice of Punjab and Haryana High Court, Chandigarh on 2nd June 2018 and was elevated as the Judge of Supreme Court of India with effect from 23rd September 2019. May I again request all of you to kindly welcome Thank you very much. Honorable Justice Mr. Rakesh Kumar Jain, Member Judicial, NCLAT New Delhi, born on 1st October 1958 at Hisar, Haryana, in the family of advocates. His father, Shri Gulab Singh Jain, was eminent taxation lawyer and MLA from Hisar. I am told that his father was also present in Kolkata at Ijra Street. So I think a lot of memories for you, sir. After obtaining degree of BCom LLB, enrolled as an advocate with the Bar Council of Punjab and Haryana at Chandigarh, and after a short stint of practice in the District Court at Hisar, shifted to Chandigarh to practice in the Punjab and Haryana High Court. He remained executive member of the Bar Association of Punjab and Haryana High Court twice, and after practicing practically in all branches of law, elevated as a judge of Punjab and Haryana High Court in the year 2007 and retired in the year 2020. He was appointed as the monitoring judge by the Honorable Supreme Court in the matter of V. Lakhimpur violence case and thereafter appointed as a judicial member of the National Company Law Appellate Tribunal Principal Bench in Delhi with effect on 17th May 2022. Thank you very much, sir, for gracing us. Mr. Atul Nanda, Senior Advocate, Supreme Court of India and former Advocate General, Punjab. Presently a designated Senior Advocate with a legal practice spanning over 30 years with a specialization in litigation, project setup related strategy and advisory services. He has a strong background of litigation expertise in constitutional and commercial law, defense, aviation minister, and indirect taxation, customs and excise. He has also acted as an arbitrator as well as legal counsels in several commercial disputes. He is based in New Delhi with a primary practice in the Supreme Court of India and various high courts in his country. He has held the constitutional post of the Advocate General of Punjab from 2017 to 2021. Thank you very much, sir, for being here amongst us. Now I would request the convener of the ACAE Chartered Accountants CPE Study Circle of the Eirc of Icai to deliver his welcome address.
Thank you. Respected Chief Guest of the Conclave, the Honorable Justice Krishna Murari Sir, Guest of Honor Justice Rakesh Kumar Jain Sir, Honorable Member Judicial NC LAT New Delhi, Special Guest Mr. Atul Nanda, Senior Advocate, Honorable Supreme Court of India and former Advocate General State of Punjab, Chairman of Eirc C. Divine Patra and other regional council members present here, and all the past chairmen and council members of the ICAI, all the dignitaries on and off the dais, ladies and gentlemen. It gives me immense pleasure to welcome you all to this IBC Conclave 2023 today. It is an honor to have with us the Chief Guest of the Conclave, the Honorable Supreme Court Judge and most respected Honorable Justice Krishna Murari. Guest of Honor Honorable Justice Rakesh Kumar Jain, Member Judicial NCLAT. Special Guest Mr. Atul Nanda, Senior Advocate. Sir, we are extremely grateful to have you here with us today, and I also express my deep sense of gratitude to all of you. Your presence adds great value to this event, and we are privileged to have the opportunity to learn from your wisdom and experience. Your kind presence and wisdom shall immensely benefit all the participants, and it is a moment of pride for our city of joy. We have a rich history of legacy of judges who are known for farsighted and above-reproach conduct, which has become a hallmark for generations to come. The judiciary has consistently maintained the highest standard of conduct while discharging its responsibilities. It is the most trusted institution in the eyes of the people. We have gathered here to discuss and deliberate on various aspects of insolvency and bankruptcy code in our country. The IBC provides 4 pillars under its ecosystem to protect, safeguard and implement the provisions of law and practices in respect of corporate insolvency resolution and liquidation. The process, namely Insolvency and Bankruptcy Board of India, Adjudicating Authority, Information Utility and Insolvency Professionals. What I admire about this law is that it looks at the professionalizing the insolvency resolution process. It enables transparency in the way the entire process is handled and allows complete and comprehensive institutionalization of the process. The regulator undertakes regular and systematic training professionals to maintain the quality of professional services provided by them. Thus, the code equipped with such a paraphernalia which not only gives it life but also enables it to be relevant, absolutely addresses the issues and concerns of the people. I think the IBC is not only paving the graceful path for anyone who seeks to get out of the business, but it is also laying ground for what an ideal law should be like. An ideal law has to think comprehensively and not just stand out in becoming a silo of legislation. It has to conceptualize a framework that is supported by an institutional mechanism and stakeholders who keep it up and going, thereby addressing the emerging concerns of the people. Features such as time-bound process, transparency, and professional dealing are all wonderfully led and embedded into the code, making it one of the most popular and robust legislation in recent times. The IBPI is regulator of a unique nature that has indeed stood the test of the time, particularly in the present time, where all the activities are benchmarked against global standards and practices. We have lined up esteemed speakers who will share their expertise and knowledge with us. The session is will cover a wide range of topics ranging from expectation from insolvency professional, role of stakeholders in fast-tracking revival process, emerging role of IU under the code, the structure and role of bad bank in IBC, and tax implication while formulating a resolution plan or dissolution. Today's conclave is aimed at providing a platform for experts, industry leaders, policymakers, and practitioners to share their insights, experience, and best practices related to the code. It promises to be an enlightening and enriching experience for all participants. I would like to thank all the participants for joining us today and making this event a grand success. I hope this conclave will provide valuable insights and learning to all of us. On behalf of ACA Chartered Accountant Study Circle of EIRC of ICI, I welcome you all once again, and I extend a warm welcome to our respective Chief Guest of the conclave, the Honorable Chief Justice Sri Krishna Murari Sir, Guest of Honor Justice Rakesh Kumar Sir, Special Guest Mr. Atul Das Sir, and all the valuable guests and participants. Thank you. Thank you very much.
May I now request the Chairman of the Eastern India Regional Council of the Institute of Chartered Accountants of India, C.A. Devayan Patro, to deliver his address.
I have been told that time is at a premium, so I'll not waste much time. A very good morning to dignitaries on the dais, off the dais, and kudos to the team of the ACAE CACP Study Circle of EIRC for organizing such a wonderful program where IBC professionals are there. And when you talk about insolvency professionals, you must understand that it's very, very important, because there are assets in our economy which we are unable to utilize properly in the way we need to do so that the dreams of the Prime Minister can be achieved. And the IBC professionals, the insolvency professionals, are playing a great role to bring back those assets to the mainstream of this economy. I think the IBC professionals deserve a big round of applause. We all know 70% of the the insolvency professionals are chartered accountants. And that is possible only because of the curriculum that the institute and our forefathers had laid down. And I can tell you that chartered accountants are the ones who can understand the flow of data, whether financial or non-financial, within an organization, and are also able to correlate them. And that is why so many of them are insolvency professionals. And not only that, in the IBC process, you need forensic auditors, you need valuers, and you will again find that the majority of them are chartered accountants. So a big round of applause for all the chartered accountants. I think the dream that the Prime Minister has seen, the long-term dream, 100 years of India and 50 trillion economy, it's a long-term dream, but that can be achieved only by putting a lot of hard work every day on the short-term goals that we create to achieve the long-term goal. And that is something that we have to pursue on a regular basis. In the end, for any society, any country, it's very important to have a proper legal framework. In India, we are lucky that in a country having such a big geography, having such a huge population, has a constitution in place, and we are happy that we have amongst us persons who are part and parcel of protecting that constitution, and they are the ones who provide us justice. And without justice, there is no meaning of a cultured society. So a big round of applause for all our guests. With this, I wish that this program is a grand success, and thank you very much for inviting me.
Thank you, Devayan. It's always a pleasure to listen to you, short and crisp and to the point. I want to increase your pleasure further by inviting our special guest today, Senior Advocate Mr. Atul Nanda, for his address. So please.
बंद कर दो अपने का चार्ज होता है थोड़ा सा लेके कार्ड ले जाओ उसके बाद तो बाइक जाएगी चार्ज कर लेना है
Shall I say good morning? It's 8 minutes to good afternoon. Honorable Justice Kishan Murali ji, Judge Supreme Court of India, Justice Acae Jain retired, Honorable Member NCL-AD, Mr. Icai, Mr. Binani, especially Mrs. Binani because I had an occasion to work with her, Mr. Patra, other dignitaries on the dais, off the dais, and the country's most erudite resolution professionals and chartered accountants. I say good morning to all of you, and I thank my former junior associate, Mr. Sandeep Bajaj, having given me an opportunity to be amongst all of you today. I was looking at the minute-to-minute program and I was allotted 11:42 to 12. So I have 5 more minutes to address you. As they say that resolution professionals are the crucial pillars upon which rests the effective, timely functioning as well as credibility of the entire edifice of the insolvency and bankruptcy resolution process. Whether this set of RPs, the resolution professionals, who are the most crucial link between an economy, effective implementation of a law which has been conceived for the purposes of better management of the financial resources we have, are meted out the true treatment which they deserve under the IBC, or their job is to do everything and get nothing in return. It's a thankless job. Whether there is adequate protection for them. When we talk about judiciary, they say independence of judiciary is very important because if you want to disperse justice, then the judge must be insulated from any fear. Whether these resolution professionals who are actually performing the job of a board of directors for which a company is created, with board of directors not even willing to look at them, is provided with that protection is something which I want to address this August gathering. I don't want to sound knowledgeable in this regard, but I just want to throw this for you to ponder over, because it is organizations like this who are going to provide for a springboard for government to even start thinking about you. Now just to further amplify on what the point I am trying to make. A resolution professional is always faced with a threat from the erstwhile management. I have examples galore, even as back in 21, that there were resolution professionals who were beaten up by the erstwhile managers, erstwhile management of a CD. I have examples galore where many a time NCLT, and in one occasion, Supreme Court to intervene in a matter where a FIR is lodged against a resolution professional and he was arrested. It is only on the intervention of Supreme Court that the person was protected. Not only that, I am surprised that now I am told that resolution professionals are considered to be public servants. And there are Prevention of Corruption Act matters which are lodged against them. I'll give you an example, and I'm not going to quote at the moment, read the code. If you look at the IBC for a minute, where a liquidator appointed under the Companies Act under 502 is a person appointed by a court and therefore satisfies the definition of a public servant. Here, you may be appointed as an interim resolution professional by NCLT, but eventually your appointment is seconded by COC. And if I may put it in the right perspective, it is COC which is actually your appointing authority and not a court of law. If that be so, that you are to be considered as public servants and therefore you should be exposed to all this CBIs and so-called enforcement directorate and all, then why, for a strange reason, under 232 of the code, why RPs are not mentioned? 232 of the code defines what is a public servant under section 21 of the Indian Penal Code. There is no reason for legislature to not mention RPs there. The point I am trying to make here is that RPs in an industry is like a mother who nurtures a going concern or a sick concern which the mother is putting its best either to revive or to extract the best benefit. And like the mother, the father says, you don't do anything, the relative says, you don't do anything, and at the end of the day, even children say, Mom, you didn't do enough. I have penned down a few lines for the purposes of this elite class, and I think it is time that organizations like you should stand up, amplify the problems you face of such nature, of harassment by a erstwhile manager, by criminal intimidation of lodging of prosecution, enforcement directorate, and thereafter, after doing everything, standing in a court as a litigant. Not only that, the court gives a very tight schedule, 180 days, in which you have to finish the process. But if you really ask me, today the law is in infancy. There are a lot of people. There is huge confusion in various areas of law. Many times, the RPs would require guidance from NCLT. I have seen cases where the board, which is your disciplinary authority, have debarred professionals for application for clarification before NCLT and they have said you have not done enough. Not only that, I have come across a case where auction failed 12 times. 13th time, when it was advertised on the day of the auction, there was some technical glitch in an affidavit file. The RP said, let the auction take place the very next day. Auction was successful. After that, he was crucified by the board by saying that even on the next day, you should have taken the highest value as the base value for the purposes of auction. Since you didn't do that, so 2 years debarment. Now, what I see here, that the backbone, the pillar of IBC is meted out with a treatment which is not appropriate for the purposes and institution which is RP, which is actually the Bhisham Pitama of the IBC court. And I say this, being a caretaker is and never will be an easy job. You are a caretaker. Being a caretaker is and never will be an easy job. In fact, it is the hardest job in the world and many times a thankless job. You have to be the pillar of the strength even when you feel like you are crumbling to pieces inside. Not only that, and I say this, and please listen to these lines, and this is what I feel at the moment RP's plight is, and whatever your principal body is who talks to the government, I would request you that at the moment I am seeing that the show cause notices to these RPs are on the verge of increase. Today you are performing a job which may render many of them without any fault jobless. So it is time for you to now come together, put your heads together and talk to the government. I'll give you an example. I'm not saying this in here. The last matter which I did against my wife, who's sitting, you met her, was in the year 2004. And I lost that matter, obviously. This was a matter which is called Jacob Matthew versus State of Punjab. I appeared for State of Punjab. She at that time was working with then the Solicitor General, later became the Attorney General of India. Now what I say is that every mistake which an RP may commit during the discharge of his function may not be malafide. It may be a mistake which is bona fide. Every negligence is not with a criminal intent. When you talk about doctors, now what you will see, which I have seen, I have got the data and I don't want to, burden you with that data, that how the show cause notices against the RPs on frivolous grounds are on the increase. And it will become a menace, it will become a cancer which will be hard. Similar cancer, similar menace was faced by the doctors. In Punjab, somebody's father died, old man died, but the doctor is at fault. Everybody thinks if somebody has died, there is a negligence on behalf of the doctor. In Punjab, तो दो चार मार भी देते. Not only that, because the police used to pick up those doctors every second day. So this became a menace. And the Supreme Court said that now the only action can be taken on criminal side against a doctor would be if there is a medical board which is set up, and the medical board so says that this was such a grave negligence that a prudent person could not have done it. Only then there can be an FIR. Today, a going concern, there is another problem which I in my experience have seen. Now the companies who've gone bad, they have taken loans. Now all loans which cannot be repaid have become a subject matter of 420, 406 of the Indian Penal Code. There is a fraud, whether it was genuine or otherwise. You have taken a loan, you have not been able to repay, there is an application, but there is a criminal angle, so and so, so and so, so and so has given a loan is for 20 CBI, this, that. Now the company's board has been removed, you've been put in place. Every second day, the investigator will call you. Yes, you are a repository of data, you are bound to supply it. But a RP will be called at 10 o'clock in the morning. The officer will arrive at 3 o'clock in the evening, and he will be made to sit till 10 o'clock. Then who is going to realize this Prime Minister's dream of bringing the other industries which he is catering to? So there is a necessity, there is a huge necessity for you. I am cautioning you today. I have seen the trends of litigation in past 30 years. This is going to increase. Now coming back to this Jacob Matthew, there must be guidelines in lines of Jacob Matthew that only in circumstances which is so grave that an ordinary chartered accountant will not take such a step, then only somebody can be subject to criminal prosecution, intimidations like this. Otherwise, a time will come when anybody and everybody sitting in this room will be sitting in a thana. Now, you are a chartered accountant. You know your accounts. A thanedar will not know his accounts. Even I have dealt with what you call enforcement directorates. How many of them understand accounts? How many of them understand audit? None of them. And I say this, and I will conclude what I wanted to say, and often our good deeds make enemies for us. Often our good deeds make enemies for us, and the ungrateful person despises us on two counts. For he is not only unwilling to acknowledge the gratitude he owes us, he does not want to have his benefactor as a witness to his thankless behavior. And I conclude my address, and this is what I really feel, because I know that you are doing a yeoman service to the economic growth, or at least depletion of this country. But this is, I conclude this, the plight of RPs, which I feel, with a shares, few small poem by Javed Akhtar Saab. And he says this, and I quote, he says, "Girte hain hum bhi dar badar, girte hain hum bhi dar badar, kabhi is nagar, kabhi us nagar, ek dusre ke hum safar mein aur meri आवाज़." RP है, अपॉइंट हो गया, सीडी के ना स्टाफ कोऑपरेट करने के लिए तैयार है, ना कोई दूसरी सरमाई है, ना पेपर मिलेंगे, पर मेरे को 180 दिन में काम करना है। गिरते हैं हम भी दर बदर, कभी इस नगर कभी उस नगर, एक दूसरे के हम सफर में और मेरी आवारगी, मेरा अकेलापन। ना आशियां हर एक नजर, ना आशियां हर एक नजर, ना रहनुमा हर रह गुजर, अब जाए तो जाए किधर मैं और मेरी आवाज़। जीना बहुत आसान था इन द एंड ऑफ द डे, जीना बहुत आसान था। मैं तो चार्टर्ड अकाउंटेंट था, 4 रिटर्न भरता था, रिटेनर के पैसे आते थे, बल्ले बल्ले काम था। जीना बहुत आसान था, एक शख्स का एहसान था, मन में एक अरमान था जो ख्वाब का सामान था। जीना बहुत आसान था, एक शख्स का एहसान था, मन में एक अरमान था जो ख्वाब का सामान था। अब ख्वाब है ना आरज़ू, अरमान है ना जस्तजू, जो भी बहुत खुश है मगर मैं और मेरी आवाज़।
Thank you, sir. Thank you very much. I've got a very pleasant task to invite our guest of honor, Honorable Mr. Justice Rakesh Kumar Jain, for his address. Please.
Honorable Mr. Justice Krishna Murari, Judge Supreme Court of India, Mr. Atul, Senior Advocate and former Advocate General Punjab, distinguished panelists, Mr. Bapra, Mr. Bilani, Mr. Batra, ladies and gentlemen, good afternoon to all of you. It is indeed an honor for me to be here with you to discuss about the Insolvency and Bankruptcy Code. Till the code came into being, the Companies Act 2013 directed winding up and distribution of the assets of the company after liquidation. But with the enactment of the Insolvency and Bankruptcy Code in the year 2016, the focus is now on the revival of the companies which otherwise would have ceased to exist on account of liquidation. Therefore, the code aims to cover bankrupt individuals, companies and partnerships to revive their financial viability in an expeditious manner. It provides a time-bound and straightforward insolvency resolution procedure through the National Company Law Tribunal and with the appointment of interim resolution professional to handle the assets of the concerned entity and to consolidate the claims. One of the primary features of the IBC is the establishment of a time-bound resolution process, which means that once the insolvency proceedings are initiated, then there is a strict timeline within which the resolution has to be achieved. The time-bound approach is for the purpose of preventing delays and to encourage prompt decision-making, efficient utilization of resources, and maximization of value of the assets of the debtor. In this regard, insolvency professionals play a key role who are licensed individuals having specialized knowledge who act between the debtor and the creditor and assume the responsibility of managing the insolvency process. The insolvency professionals ensure that the insolvency proceedings are conducted impartially, professionally, and in accordance with the provisions of the IBC. It is needless to mention that the establishment of the Insolvency and Bankruptcy Board of India as the regulatory authority has further strengthened the framework. I don't want to go into minute details of the provisions of the code, which all of you know better than me, being highly qualified and experienced professionals. But it would be suffice to mention that a huge responsibility is fastened upon insolvency professional who has to take the charge of the day-to-day operations and has to work towards finding a viable resolution. The interim resolution professional has to be neutral to facilitate discussions and negotiations, ensuring that all the stakeholders have their voice in the resolution process, which builds trust in resolving conflicts and serves the best interest of all the parties involved. The Honorable Supreme Court has been guiding the appellate tribunal and the tribunals by interpreting the provisions of the code and the regulations. Like in the case of Swiss Ribbons, it has been held that the resolution professional does not possess the adjudicatory power, but after his appointment, the management of the company is entrusted to him and the powers of the company's directors are suspended. Therefore, there is a huge responsibility on his shoulders to keep the company as a going concern and also to abide by the statutory provisions while discharging his multifarious duties and responsibilities. The selection of the Eirc depends upon the party initiating the insolvency proceedings. If the application is made by the financial creditor or the corporate debtor, then the proposed resolution professional in the application will assume the role of the Eirc, provided there is no disciplinary proceedings pending against him or her. Whereas, in the case of an operational creditor initiating the proceedings, the adjudicating authority follows a different approach, because if the name of the entire resolution professional is not put forth, then the matter is referred to the IPBI for the recommendation of the insolvency professional to act as Eirc. But again, it is subject to absence of any pending disciplinary proceedings against him or her. As I have already said, that the integrity and independence of the Eirc is a strong criterion, which is assessed with various factors, including the eligibility to serve as an independent director on the corporate debtors board, absence of any related party relationship, no involvement in auditing, secretarial audit, cost audit, legal or consulting services with significant transactions with the corporate debtor. The Eirc, as a facilitator for creditors, receives and collates all claims submitted to him and has to ensure that the creditors' claims are properly recorded and considered during insolvency proceedings. He has the responsibility of auditing the assets of the corporate debtor and managing its operations until the Eirc is appointed by the Committee of Creditors. Thus, looking from any angle, the Eirc has a pivotal role in the insolvency resolution process as he carries out a crucial task in achieving a fair resolution. The resolution plan received from the prospective resolution applicants are evaluated based on various parameters, including feasibility, viability, and the potential to maximize the value of the assets. And each proposal has to be reviewed, and once the resolution plan is finalized in consultation with the COC, the same has to be submitted to the National Company Law Tribunal for its approval. After sharing briefly about the broad outlines of the code and the duties and responsibilities of the Eirc, I would like to mention that the code, which is complete in itself, got the consent of the President of India on 28th of May 2016 and has repealed the Presidency Council on Insolvency Act of 1909 and the Provincial Insolvency Act 1920. It is comparatively a new act which is going to complete its 7th year in this month of May 2023. But during its journey so far, it has undergone 6 amendments and there have been 84 amendments to its 18 regulations by the IBBI. As per the data collected, 6,571 CIRP had been initiated by the end of March 2023, out of which 4,550 have already been closed. This has happened only because of the relentless work done by all the stakeholders, including the National Company Law Tribunals across the country. As I have earlier said that it is a new code and it is at the stage of evolution, and as such, the laws have been evolved by the Honorable Apex Court from time to time. For example, the law in regard to limitation, on account of which various meritorious cases, especially pertaining to the banks, face dismissal and causes unjust enrichment to the other party. But the law has been evolved by referring to Section 18 and 19 of the Limitation Act, acknowledgement of the debt on the basis of balance sheets, innovation of contract in terms of Section 25A of the Contract Act, and from the date of issuance of recovery certificate by the DRT, etc. Similarly, the legislature has found that the petition filed in Section 7 and 9 or 10 for initiation of the CRP proceedings can also be dismissed as withdrawn on a settlement, and for that matter brought the amendment in the year 2018 by inserting Section 12A in the code. These are all signs of evolution. During my short span of time as a judicial member, I have found that most of the petitions are filed either under Section 7 or Section 9 of the code. Insofar as the application under Section 7 is concerned, it generally involves a huge amount in comparison to the amount involved in the application filed under Section 9, which are filed in respect of supply of goods or services rendered, and many a times the amount involved is not that much for which a good company should be driven to do CIR. In such type of cases, generally a question comes to my mind about the application of alternate dispute resolution mechanism, much less the mechanism of mediation before the application is admitted by the NCS. The process of mediation involves engagement of a third party expert who always gives a bouquet of suggestions, out of which any of the suggestions suitable to the parties may be adopted and the company can be saved from the rigors of the CIR. The United States of America has been at the forefront of applying mediation at various stages of bankruptcy proceedings like claims, creditors' disputes, resolution plans, avoidance, transactions, and group insolvency. Therefore, mediation can be a viable option in a country like India, where the population is enormous and wealth is not equally distributed. Mediation has already been implemented by the judiciary in the cases of family and property disputes. I can share with you some instances are there. When I was there in the High Court of Punjab and as a judge, we had the roster of matrimonial cases, we had the roster of civil disputes like regular civil appeals. So in the cases of the family disputes, where husband and wife are pitted against each other, the first thing we used to do was to call the parties in our chamber for the purpose of reconciliation of the dispute. This was a sort of mediation by the bench itself, and the purpose was to save the marriage. Similarly, in the cases where there was a dispute about the custody of the minor children, in those cases also we used to call the parties to our chamber and used to talk to the parents and the parties and the children separately to know about their point of mind, and ultimately in some cases we used to succeed, but in some cases we used to fail because the parties used to be adamant to contest the litigation. But all those purposes, the mediation of the court was either to save the marriage or to save the family from getting ruined because of the litigation process. This is because the focus of mediation is on finding solutions that will resolve the concerns of both the parties, and parties are free to make their own decision. It is a voluntary process, and the duty of the mediator is to bring the parties to a mutually agreed solution. As of now, mediation is not utilized for resolving the insolvency disputes, but it is provided in various acts like Section 442 of the Companies Act 2013 provides for referral of company disputes to mediation by the National Company Law Tribunal and Appellate Tribunal. It is to be read with the Companies Mediation and Conciliation Rules 2016. Section 12A of the Commercial Codes Act 2015 provides for pre-institution mediation in commercial disputes. Section 32G of the Real Estate Regulation and Development Act 2016, in short ERA, provides for amicable conciliation of disputes between the promoters and the allottees through dispute settlement forum set up by the consumer or promoter associations. Section 37 and Section 74 to 81 of the Consumer Protection Act provides for reference of a dispute to mediation as an ADR mechanism and setting up of a consumer mediation cell at each of the district commissions, state commissions and national commission. Section 18 of the Micro, Small and Medium Enterprises Development Act 2006 mandates conciliation when dispute arises on payments to the MSMEs. Section 4 of the Industrial Disputes Act 1947 authorizes the appropriate government to engage such number of persons as may be deemed necessary by notification in the official gazette as conciliation officers for discharging the responsibility of mediation in and promoting the settlement of industrial disputes. Section 12 of the Industrial Disputes Act 1947 provides duties of conciliation officers. The Government of India I am told that Government of India is bringing Mediation Act also. For that, Mediation Bill 2021 has been introduced in the Rajya Sabha on December 20, 2021 with the aim to promote, encourage and facilitate mediation, especially in the institutional mediation. The bill requires persons to try settle civil or commercial disputes through mediation before approaching any court or trial. For mediation to be effective in cases of insolvency and bankruptcy, moratorium provisions under the country's IBC that mandate the stalling of ongoing civil legal proceedings until the CRP's conclusion need to be modified appropriately. Suitable steps should also be taken to lay down mediation-related provisions that cover the enforceability of mediated settlements and the roles, rights and responsibilities of insolvency professionals, other stakeholders. As such, an exercise would grant an out-of-court mediation the requisite legal gap to ensure discipline and proper enforcement. Mediation under a formal insolvency resolution process may prove more helpful than a protected resolution plan aimed at business restructuring or liquidation. It is now well appreciated that the interest of home buyers in cases of insolvent housing construction companies would have been better served through mediation. I have also taken down the advantages of mediation, particularly in resolving commercial disputes, like speedier and cost-effective mechanism compared to litigation, sustain the business relationships through relatively non-adversarial approach, addressing the underlying stigma attached to insolvency in view of confidentiality, flexible and more controllable over court-driven process, results in solution acceptable to all, obviating the need of further appeals. Mediation is thus an informal process which comes to an end in a few sittings and is very cost efficient compared to the formal process in the course of law. But since the IBC lacks provisions for special out-of-court restructuring mechanism such as mediation, the stakeholders are forced to choose the only default option, that is formal insolvency resolution procedure. So it is my humble opinion, it is perhaps the time that mediation will be used according to the timeline provided in section 12 of the code. I may reiterate that it is my humble opinion and a food for thought and nothing beyond that. In the end, I express my gratitude to all the organizers of this event and also for giving me a chance to participate in it. Thank you once again. Jai.
our privilege to welcome the chief guest, Honorable Mr. Justice Krishna Murari, to deliver his inaugural address.
My friend Atul Nanda was in a dilemma whether to say good morning, good afternoon. So I will only say namaskar. Mr. Justice Rajesh Kumar Jain, a former judge of Punjab and Haryana High Court and presently member NCLAT. Mr. Atul Nanda, he has, but I will only address him as my good old dear friend. Mr. Anup Kumar Banka, convener, Mr. Vikas Kumar Banka, deputy convener, Mr. Devyan Patra, the chairman, and distinguished chartered accountants and resolution professionals present in the hall. Ladies and gentlemen, first of all, let me extend my thanks to all of you for giving me this opportunity to be here with all of you and also to address the experts in the field. At the outset, I may tell you that the topic on which I have been asked to speak on the issues of insolvency and bankruptcy in the presence of subject experts and doyens of the field makes me feel very timid. Because, oh, it's a fact. See, when the IBC came, we had already left practice and we were, at least I can say I was a judge. The High Court, jurisdiction of the High Court is totally excluded. So the only exposure which we could, whatever little exposure I could get it when I moved to the Supreme Court. But you only get the insight of the particular act when you actually work on it, when you actually practice it. So therefore, there is nothing unusual in my saying that I feel very timid before all of you, because all of you are having practical experience and knowledge of the working and functioning of the Act, the procedure. Of course, Mr. Jain, Mr. Justice Rakesh Jain can be an exception because he has attained the practical experience after being member of the NCLAT. I am too sure that all of you present here are far too familiar with the subject, nuances and the intricacies of the insolvency and bankruptcy code. However, today I would like to shed light and talk to you on the constitutional understanding of the subject jurisprudence, particularly the constitutional underpinnings of the treatment of operational creditors, especially with respect to MSMEs. Operational creditors under the current regime are being subject to significant haircuts. You must be knowing this from your own experience, often reaching as high as 100%. Without any means to challenge such mandates or having a major say in the matter. First and the foremost, in my humble opinion, it is crucial to understand who operational creditors are within the economic landscape. Operational creditors are entities that provide goods or services to a company in the regular course of business, rather than acting as financial creditors who extend loan or credits. These operational creditors play a pivotal role in supporting the business by offering essential input, supplies and services required for day-to-day operations of a business entity. Their contributions are vital to the overall functioning of our economy. And I will say that they are anyway no less than the financial creditors, because a business empire set up and stands with the help of financial creditors, but runs with the help of operational creditors. So if empire is there and it cannot run for want of operational creditors, then it will be loss for everybody. But what we find from the going through the Act or the provisions of the Act, very unfortunately, operational creditors often find themselves at a severe disadvantage when it comes to the recovery of their dues. In certain instances, they are forced to endure haircuts, which essentially means accepting a reduced amount, sometimes even foregoing the entity of their outstanding dues. What makes the situation even more problematic, especially in the constitutional context, is the lack of avenues to challenge such mandates or to raise their grievance and their concerns. This lack of recourse to the operational creditors subverts the right to be heard against injustice in proper and competent forums, undermines the principles of fairness and equality that our Constitution upholds. It is a fundamental principle in law that the Constitution acts as a peg that supports all the statutory frameworks that flow from it. Therefore, even in the sphere of law, which on the face, due to their hyper-technicality, show a dissonance from the general constitutional jurisprudence, they in fact only fall from and gain their logic from the Constitution itself. In light of this, it becomes a matter of utmost importance to understand the general logic that runs through the veins of the Constitution. In order to correctly interpret seemingly hyper-technical laws like the present one, the insolvency and the bankruptcy code. The history of our Constitution and the historical context in which it was constructed would show that its development was a resistance against the arbitrary and unfettered power of the colonial state. The colonial laws that governed our nation before the enactment of the Constitution worked within a framework of logic that gave every benefit to the decisions of the colonial state over the public good to ensure total and absolute control of the imperial authorities at the cost of the right to accountable loss. If you analyze it, this logic in essence meant that no action of the state was allowed to be questioned, forming the very basis of the notion, which is very often said that king can do no wrong. It was against this very notion that allowed for an unfettered use of power that the Constitution was born. Unlike the colonial laws, the Constitution of India, whether it be through the basic structure doctrine or through the rights enshrined in the Golden Triangle, propounded a logic that subscribed to view wherein at every instance, every action of the state can be put to a question. The basic logic that forms the bedrock of the Constitution must also apply to the insolvency and bankruptcy code. And every operational creditor who faces potential injustice must be granted the right to a fair hearing before a competent forum. See, to uphold the constitutional principles within the treatment of operational creditors, we must strive for balance, particularly when it comes to MSME sector. MSMEs are the backbone of our economy, representing a significant portion of our business and providing employment to millions of people of this country. They are often reliant on timely payment of the dues to sustain their operations, invest in growth and contribute to the nation's progress overall. The prevailing practices, as you must have noticed from your own experience, often neglect the need for balance in the treatment of creditors from different classes, disproportionately affecting the MSME sector. this imbalance can lead to detrimental consequences such as disruption of cash flow, loss of jobs, and entrepreneurship itself. It is imperative that we recognize the significance of a fair and equitable treatment to all creditors, especially MSMEs, in order to foster a sustainable and inclusive economic environment. If you examine the provisions of the Act in the light of these considerations, it is crucial that an immediate action to rectify the existing imbalance in the treatment of operational creditors be undertaken. We need a robust legal framework that empowers operational creditors and provides them with a means to challenge unfair mandates or decisions. A transparent and accessible dispute resolution mechanism must be established, enabling them to voice their concern and seek redressal effectively. Furthermore, what is further required is a culture of responsible borrowing and lending, where the interests of all the stakeholders are given due consideration. Financial institutions and corporations have more moral and ethical obligation to act with integrity, ensuring that the rights of operational creditors are respected, not only respected but protected as well. Transparency and accountability should guide their actions, fostering an environment of trust and mutual benefit. To conclude, it can be said that the constitutional principles of justice, equality, and protection of individual rights must also be extended to the operational creditors. In our collective responsibility to ensure their rights are upheld, particularly with regard to the MSME sector, which plays a very vital role in our country. I would say let us work together to establish a system that strikes a fair balance between the rights of different classes of creditors, fostering an environment of inclusivity, growth, and sustainable economic development. So this, by means of this conference, we can say that actually our debate on this lacking in the provisions can be started. As you all know, our constitution itself is a result of the debate. You must have read the constitutional debates which took place in the parliament, which ultimately led to passing of the constitution as it exists today. So, you are all professionals, chartered accountants. If a debate is started on this issue, then tomorrow, day after tomorrow, after some time, these imbalances may be removed. In a democratic setup, debates are the only means by which any such change, if required, can be achieved. With this, I wish you all the best. Start the debate and let's see, maybe this lacking in the provisions of the Act is removed by your efforts. Once again, I thank you all for giving me this opportunity to be with all of you. Thank you so much.
Thank you very much for leaving a thought with us, sir. Very enlightening that a debate must start, and I'm sure that we are all going to ponder over it and take it forward. So with the permission of the guests out here, can we take 2 or 3 questions as the audience? That's a popular demand over here, at least. So before the questions, I think. So before taking questions, I think I would like to invite CA Rashmi Chowcharia and CA Neeraj Agarwal on the occasion of this conference, we have compiled a souvenir containing articles and knowledge articles so that it could be circulated to all the members. So we would like to have it released from your office. So Neeraj and Rashmi kindly come forward. Neeraj Agarwal. Yeah, go ahead. Thank you. So we will take 3 questions. Yes. Mic to the table. And mic is.
Good afternoon. My question is to Honorable Justice Rakesh Jain sir. Sir, in mediation proceedings, how do you see the efficacy of ODR? In mediation proceedings, how do you see the efficacy of online dispute resolution systems?
Online
Dispute resolution system.
online dispute resolutions.
Yes.
You see, ADR means Automated Dispute Resolution Mechanism. And if everything is going on online, like you are talking about virtual,
Yes, sir.
on the virtual basis,
The bill which is passed, which is in Rajya Sabha, is basically that has been which is submitted by Niti Aayog.
yes.
It focuses on online dispute resolution system also.
Actually, I have not read that bill, frankly speaking, so I can't answer this question. That the bill is also aiming about the online resolution disputes mechanism. Because everything these days are going on online only. We have been holding our court, NCLT also, Chennai bench also, and Delhi principal bench, Chennai bench, all online. As you said, virtual means online.
Yes, sir.
So we are doing it virtual only. So if for that matter the parties can choose their, because mediation is a matter of confidence and confidentiality. The parties have to sit together and I don't know whether the online proceeding would be confidential or not. I do not know about that, whether it would be confidential or not, because in mediation the parties sit with the mediator, both the parties are there, mediator has a bouquet of questions or answers and resolutions. He offers those resolutions to both the parties. That if you, supposing I tell you one example, there was a manufacturer of jeans in Ludhiana. He was copying Levi's and he was selling the jeans in the market with the label of Levi's and he was copying it. When Levi's came to know about it, they instituted civil suit at Ludhiana, trademark, etc. Then the matter went into the mediation and the mediator gave a suggestion to the Levi's that why don't you get your jeans manufactured from them if they are so good in copying. So then matter was resolved. So mediation acts like that. In my humble view, as we say that the first hour of justice is the hour of compromise. So instead of fighting and protracted litigation for years together, if the matter can be resolved by way of the third party resolution, third party's intervention or suggestion, then why to break your head so far as long litigation is concerned? As you know that even in the dispute between the husband and wife, there is always a third party, pati patni or both. So similarly, in the dispute of family dispute also, there is a third party. I tell you one example. When I was holding the criminal roster in High Court, dealing with the bail application, anticipatory regular bail application, quashing of the FIRs and complaints, etc. I came across a case which was in which it was a FIR registered by, there were 8 brothers and sisters, Agarwals. Their father was some Rai Bahadur and was running huge property in Punjab. So the youngest one, who was perhaps 60 years of age, because there might be 2 years, 3 years gap, and there were 8 brothers and sisters. He registered the FIR against his 5 brothers and 2 sisters, saying that small piece of land has been sold by them without his consent. And that property, his photograph is not there in the sale deed. So naturally, he had a case. So he registered the FIR 420, 467, 471 IPC, etc. That bail application, anticipatory bail application, was dismissed by the trial judge, I mean the sessions court. It came up before me. When I was hearing the bail application, I read the bail application at home, and I went through the properties the family owned at that time. And the property which was in dispute was only of rupees 80 lakhs, in which the youngest son, was getting only 10 lakh rupees. It struck to me that I should mediate in this case instead of deciding on merits. So both the parties engaged top lawyers of the High Court with charging 5-10 lakh rupees. So I asked them to come to my chamber because of the confidentiality. And as a High Court judge, you can do it. So I asked both the lawyers for the parties to come to my chamber. I asked the youngest one, see how I mediate, because I also belong in our family, and I also have a number of brothers and sisters. So I knew about the structure of a big family, a joint family. So I used that experience of my life in that case. I asked the youngest brother that supposing all these brothers and sisters are wrong and they should not have sold your property because only your head is being shown in the photograph which is appended to the sale deed and you are not visible there. So you may be right, ultimately the FIR may be convicted or whatever. What will you get over? Could you answer my question? I said that today after these brothers and sisters are together, tomorrow you will be alone out of the family. And you have yet to, I asked them, your children are married or not? He said, we are yet to be married. Then I told him that if this 10 lakh rupees will cost you throughout your life, don't save the relation instead of getting the money, because this money is not earned by you. It is given to you by your parents, to your father. So I don't know how, but it stuck to them. And ultimately, I granted the bail, I passed their FIR. So this was a small piece of mediation which I did in my chamber, in a criminal matter. So that is why I chose this subject today for the purpose of my speech, that how mediation is relevant in these matters also, because my experience, so far as I am only 1 year old, so far as the NCLT is concerned. In May, I was appointed and it is 1 year has passed. During this period, I have experienced 2 things. One about this, that small matters in which this operational creditors are asking for 4-5 crore rupees and they are driving it, and the NCLT is passing the order of admission, they are loggers that will be brought in court. If matter is taken to the mediator, perhaps in regard to the installments, matter can be resolved, about the rate of interest could be reduced. So these are the things. That is why I chose the subject of mediation, because it is not there in IBC. And in the end also I have said that it is only my thought. It may not be that I am professing it. It is only my thought. Like the elder brother has said that everything starts with a debate and ultimately something comes out of it. So this is the answer, whether it is correct or not.
Thank you so much.
Sir, not that it's a question by the suggestions. Both the Supreme Court honorables and Acae is present to prevail upon ambiguity, whatever date they prescribe, 180 to 70 to 30, that should be qualified by working days. Because everyone gets the holiday, but not the RPs. That is affecting their social capital and social health. Thank you, sir.
Just a second.
Yes, sir.
Because I have to decide every day this issue. You are saying that 180 plus
Working day.
I don't know. I understood that. 180 because once supposing the matter comes to me and I decide that 180 means working day. The job is over then. This is what you are saying?
Yes.
Then what do you mean by working days? All days are working days.
All days, but the banks are open because every day they have the social functions, they
have to function with the family. Everything is getting stuck. Every RP is getting affected by these hard timelines because other organizations are not doing work, but RP has supposed to work because they meet the deadlines. So that is getting affected.
You see, this deadline is provided by the legislature. 180 days. They have set 6 months. Like I tell you, in the Commercial Courts Act, when the Commercial Courts Act was introduced in 2019, probably I don't remember correctly, 13. It was specifically mentioned that all the cases have to be decided within 6 months. I was the commercial division in the High Court as a judge. We couldn't decide it within 6 months because there are so many bottlenecks. Supposing some cases filed, the other counsel says that I will file an application, Ie has filed. Then first decide the Ie. Then after the Ie, he will go to Supreme Court. Then they will decide the Ie. So this timeline is very difficult matter. So your suggestion we have understood, but you are saying that the RP has to attend other functions also, family duties also. Once you are appointed RP, you belong to the company.
Sir, I went to one RP and in his family function, but he was working, otherwise enjoying. That was it.
Naturally, so RP is suitably paid also, there is no problem. You see, RP, a huge company. I also wonder, what's your good name?
Anil.
Mr. Anil, I also wonder, a huge company running into thousands of crores of rupees. One RP takes over the entire company. Look at the power which the RP has exercised also. So with power comes the duties also, responsibilities also. So there is no, don't compare holidays with our holidays.
Sir, I'm Mahesh Gupta. It's something come to my mind. It's not a question, but a sort of a suggestion. As we all know, the delays in NCLT and clarity is only because there are a lot of cases coming up, a lot of applications is filed, and a lot of papers are there. Judges are, members are very, it's not able to go through all the things. So my suggestion, I was thinking whether we can have some sort of a panel of experts in CLAD or NCLT so that they can scrutinize the applications whether they are relevant for the case or not. Because nowadays there are many applications which are irrelevant filed, and as a judges or member you have to attend that. So this makes a delays. Like resolution plan, it takes 6 months, 1 year to pass.
To answer your question is the very simple answer. Dr. Badai is saying that we cannot pass on this adjudicated powers to any expert. This is, you see, in the MCLAD, what we used to face, the process is so hard, even on an adjournment to go to Supreme Court.
So I'm not saying to
So
pass
I
on.
tell you why. Supposing I am saying that already you are asking for adjournment, Mr. So-and-so asking for adjournment. No, don't record my name. I am not asking that, then who is asking? Because if he says that I am asking, then he will be answerable to his client. Our client is corporate. He will say, you are a misfit for my job, that I will engage another counsel. What to do? Even small matters goes to Supreme.
Yeah, that's good. Sir, I'm
Sir,
not saying to pass on the adjudicating power, but they can assist you
Sir,
in analyzing.
Sir, can I just answer? You know, I'll give you another perspective. You are the people who engage people like us. So law firms charge by an hour, and therefore it affects their billing. 70% of these frivolous applications are actually the billing hours. This is one. So it's not about the judges. And judges can't say, a registry cannot decide whether an application is frivolous or not. So therefore, this is like labor pains. You have conceived, you have to suffer the labor pains.
One last question from the lady. One last.
Yeah, good afternoon. This is Rachna Nirvana. So I have a question like how do we see or differentiate law of limitation with regard to filing of suits or legal proceedings like Section 7, 9, 10 applications, and while the claim has been accepted by RP, because it has been seen that there are cases when the audited balance sheet is more than 4 or 5 years old. In that case also the RPs have to collate the claim and accept it. So how do we actually see the law of limitation being applied to claim collations?
You see, that is why I have said in my address that Supreme Court has been very kind to us, evolving the law of limitation. Many cases I had in my 1 year of this tenure, I had to dismiss many cases, very meritorious cases of the banks. Especially bank is the culprit. They don't file their cases in time. I don't know I should have said it or not, but this is a hard fact. They don't file their cases in time. Sometimes they mention date of default, as the date of NPA is the date, sometimes they say date of the OTS is the date. They are not sure about it. And the other party, the counsel for the corporate debtor, he will definitely take the issue that case is barred by limitation because the residuary article is applied, being an application. So 3 years power window is given. So for that, the Supreme Court, one after the other judgments have been given. Firstly, that so far as 18 is concerned, how acknowledgement, then Section 19 payment of acknowledgement, then balance sheets, the Justice recognizing judgment, balance sheets, audit balance sheet can also be acknowledgement. Then date of signing of balance sheet was the issue, because Section 19. So these are the things that the date of issues a recovery certificate of the DRT, when it was tried to be expanded in favor of the financial trade.
But sir, what should RP do by collating the claims when the audited balance sheet available is say 4 years back and we have just...
That will say in some case.
Thank you sir. Thank you very much. May I now request CA Vikas Kumar Gupta, Deputy Convener of the organization, to propose the board of tax.
Thank you, Sri Pinani ji, for giving me the opportunity to offer the hearty vote of thanks on behalf of ACE Chartered Accountant CP Study Circle of EIRC. At the very outset, I would like to express my heartfelt gratitude to our esteemed Chief Guest, Honorable Mr. Justice Krishna Murari ji, Judge of Supreme Court of India, for gracing us with his presence despite his busy schedule. Your presence has added immense value to this program, and we are truly honored. I request all the delegates, please join your hand in acknowledging that committee is lawful progressive presence. Thank you, sir. I would also like to extend my sincere thanks to our guest of honor, Honorable Mr. Justice Rakesh Kumar Jain ji, Member of National Company Law Appellate Tribunal, Delhi. Sir, we are deeply grateful for your presence and for sharing your invaluable knowledge during today's seminar. Thank you for being with us. Furthermore, I would like to express my gratitude to our special guest, Mr. Atul Manna ji, Senior Advocate of Supreme Court of India, for gracing us with his presence and making a thought-provoking address to the esteemed audience. और सर ने जो शायरी लास्ट में बोली थी ना, तो ऐसा लगता सर मेरे को एक शायरी याद आ गई सर, बदगुमान न हो कोई अंदाजे बयां देखकर, बदगुमान न हो कोई अंदाजे बयां देखकर, जब रिस्क ही जाते हैं मेहरबान को देखकर। सर के जितने अच्छे लोग जब बयान के देखिए 3-4 ऑडियंस में से सब उनकी प्रॉब्लम्स सामने आएंगी। Once again, I would like to express my gratitude to all the dignitaries present and on the dais for making event a grand success. Thank you, sir. Before we conclude, we would like to group photograph to commemorate the memorable occasion. Please come. presence, support and participation in making the event shortly successful.